Good afternoon. We do have a quorum, so I know there are a lot of committees that are meeting right now and have a lot of bills out there that are moving. So we'll try to keep this as short as possible. Of course, with the full committee, we will not be having public testimony. That is handled in the subcommittees. But anyway. Since everyone is so busy, we're going to try to roll through this as quickly as possible. I'm going to ask Sam Watson, Representative Sam Watson, if he would give our invocation this afternoon. Sam.
This day and for all your many blessings. We just thank you for this great state. We thank you for the resources that you've blessed us with. Just ask and pray that you be with us in this meeting, lead us and guide us as we make decisions for this state. Just be with all of our families and our businesses while we are away. Just thank you for everything you've given us. In your name we pray. Amen.
Amen. Thank you, sir. First bill I'm going to call is House Bill 202. Chairman Jay Powell, if you would please to the podium, please, to present your bill. No, sir, you're not going to get to sit at your seat. Floor is yours.
Thank you, Mr. Chairman, members of the committee. This is House Bill 202, and in existing code, there is a provision for the salaries of the governor, lieutenant governor, all the constitutional officers, the judiciary, and what this bill does. And if you'll look at line 11 of the bill, that $60,000, which is in code, is a little misleading. The actual salary of the governor at present is $139,339 because of increases that are given to state employees over time. And so, but the purpose of this bill is to react to the fact that we're one of the largest states. We've got a $25 billion budget. The governor is responsible for thousands of state employees, hundreds of agencies and departments and programs, and we are paying him less than you would pay a CEO in a very modest company. And I think this recognizes that our governor is on call 24 hours a day, 7 days a week, to respond to emergencies as well as to administer the budget of this state and the programs of this state, and that $175,000 is not too much to ask from the state of Georgia to pay for the governor. As a matter of comparison, Kentucky pays $140,000, North Carolina pays $142,000, Tennessee pays $187,000, and Virginia pays $175,000. So I originally had considered adjusting all the constitutional officers, but one of the things that was pointed out to me is that this governor is not requesting this pay raise, and that because of term limits, he will be leaving office in 2 years. So this is not for this governor. It is to recognize that the governor of the state needs to be paid more than $139,000. So this bill is to take effect before the new governor comes into office 2 years from now. And but because the other constitutional officers are not term limited, what the rest of this bill does is to set up a commission that will study the salaries and then make recommendations back to this legislative body to perhaps look at those salaries as well. And when I asked Legislative Council to draft up a commission to study constitutional officers and the legislative body, I was informed we had such a thing, but it had been inactive for the last 30 years. So the rest of the bill that's in Part 2 is basically a reformation of that commission to reduce the size of the commission and to designate what its responsibilities are and to update that commission so that we can actually look at and respond to current day rather than 30-year-old or at the whim of whomever. So that's what the bill does, and I would ask for your favorable consideration.
Okay, are there any questions from the committee? Do we have a motion? Oh, had a question pop up. Okay. Have a motion do pass and a second. Any further discussion? Seeing none, we'll proceed to vote. All those in favor, let it be known by saying aye. Aye. All opposed, like sign. Motion carries.
Thank you, sir.
Thank you. Next up for consideration, Chairman Earhart, House Bill 51.
Thank you, Mr. Chairman, members of the committee. I'll be necessarily brief, but I want to make sure that we spend the time on this, the serious nature of it. House Bill 51 is about due process. It's about safe campuses. It's about rights for the victim and for the accused. It's about the basic bedrock of our judicial system in this country. If you're accused of a serious felony or any crime, that you're entitled to the basic due process. And I also want to thank some of those who have really gone the extra mile for me on this. Representative Regina Quick has spent a significant amount of time and effort on this, the nuts and bolts of this, and she has a significant amount of time and effort spent in her career in this, advocating for victims, volunteering for sexual assault awareness, and she brought a great perspective to this. I wanted to thank Dean of the House, Calvin Smyrie. We've worked closely on this, and I think we've had a very collaborative relationship through this, and I'll point out some of the areas where we were able to come. I also want to thank Ms. Holly Tuckman from Cobb County and the Cobb County Live Safe group, who gave me a lot of perspective. Ladies and gentlemen, we've tried to be as open and as accommodating to all interested parties as we can here, and that's why we've taken so long with this. House Bill 51 does two things. It provides that the state of Georgia, for those who are victims and accusers, will ensure on our college campuses due process when somebody is accused of a sexual assault or a violent sexual crime. It also makes sure that we'll no longer be under the aegis of a separate system on campus that, frankly, the regents have had to spend untold millions of dollars on over the last few years responding to guidance from our federal government. And you can take it to the bank that we're going to reallocate those millions of dollars into sexual assault awareness programs on campus, to prevention efforts for campus law enforcement, to counseling resources on campus, to education on campus in these types of disgusting crimes. We're going to try to draw that back. The statistics are what they are. Let me tell you what it doesn't do. You've heard a lot about how this is taking away a victim's choices. Draw your attention to lines 27 and 28. If the felony involves an alleged sexual assault, no information which specifically identifies the victim shall be provided in a report without the consent of the victim. Without the consent of the victim. Lines 35, nothing contained in this subsection will require a victim of alleged sexual assault to cooperate with law enforcement in any investigation or to participate in any subsequent prosecution. Ladies and gentlemen, if the victim says no, this does not go forward. LC 288394S, Representative Aller. Says that the institution on lines 41 may pursue interim measures necessary to meet its duty of care. Ladies and gentlemen, a victim can go to the confidential reporting that is allowed under this bill on campus, and we've added, every time somebody wanted something from a minister to sexual assault counselors to an entire list of privilege reports, we've added those here. And they can go, and the university can make a determination that that victim needs to be taken out of that classroom, separated from that dormitory at their request, given grace with respect to withdrawal from classes. The only channel that a victim cannot take in this bill is to prosecute somebody for a felony criminal assault and have an expectation that it'll be carried out by campus administrators. These types of felony assaults belong in the civil authorities. We spend hundreds of millions of dollars each year training our civil authorities to have the sensitivity, the capacity, the knowledge to handle these types of assaults and these types of crimes. And we heard testimony from the Prosecuting Attorneys Council and the law enforcement community that says, all you need to do is give these campus administrators a few days with those cases, and they'll walk all over the evidence. They'll destroy the case, and guess what that does? That lets the bad guy walk. And that's the other thing about campus tribunals. Even if they're found responsible in the vernacular, that doesn't lock them up. That leaves them free to do the same thing over and over. We need to let our civil authorities lock up these bad people, not our campuses. And ladies and gentlemen, there are many, many reasons why we need to get here. You heard the testimony probably in the Georgia Tech hearings last year about the abuses of the system and the false allegations and reports. Georgia is losing these lawsuits. We've already paid settlements because of those false allegations. This is destroying families, it's destroying individuals, it's not keeping our campuses safe. And Mr. Chairman, I'd be more than happy to yield for questions specific to this bill, but I ask for your favorable consideration.
Okay, you do have a few questions. First is Representative Kirby.
Thank you, Mr. Chairman. You mentioned Tech, worked off a little well where Baylor, Penn State. In the simplest word, what your bill does is educate, let law enforcement investigate crimes, and everybody receives due process and protect victims in all its forms.
Very succinctly stated and true. Thank you.
Chairman Parsons.
Thank you, Chairman. Well, first of all, I appreciate all your hard work on this. What my question is, and this is just for information for myself, and you may have actually spoken to this, and I apologize if you did, and I kind of missed it. But currently, if an assault takes place on a college campus, and the college administration does whatever they're doing now to investigate that, and it turns out that in their to their belief that a perpetrator was guilty of doing something at that they made that determination at that level. What does happen then? Do they then turn it over to the local law enforcement, or what does happen at that point?
Several paths could be taken. Generally, the worst thing that a institution can do is expel the perpetrator. Of course, it's a significant taking. You've lost everything your parents have saved for your college education. You go through life with a scarlet letter on your forehead with respect to what the college found you guilty of or responsible for. Whether or not it goes to the law enforcement or not is sometimes problematic. As I said, at that time, if the standard time for these cases is running anywhere between 9 and 16 months to clear them, and that's because colleges are not civil authorities. The colleges and universities' business is education. They're not set up for the administrators to have the capacity to actually investigate and prosecute crimes of this nature. So sometimes it results in a civil prosecution. Sometimes it results in nothing done for civil at all. I mean, I've heard from defense lawyers who've told me their best friend is these college panels, because they can all they have to do is get involved. And if you ever really wanted to prosecute one of these people in the civil system, that would be the end of their capacity to get there.
If I may, and I don't want to delay that, but I want to make sure I understand. So what you're saying is that whatever the colleges do at this point, whatever their determination is, there's no criminal prosecution after that. It would have to be in the civil courts. Is that?
It would have to be in the civil courts.
Okay, thank you.
Minority Whip Hughley.
Thank you, Mr. Chairman. The chairman here asked my question, but I just wanted to say that I was quite concerned with a student who came and talked about how the testimony went in subcommittee and how people were treated. So my concern is, are you confident in this bill that we're being fair to both students who would be involved in any type of
I was also
matter?
compelled by that testimony, Representative Hughley. The treatment of survivors and victims in sexual assault is not even at best. I don't think there's a good description of it. It's extremely inconsistent across our state. We saw in Representative Holcomb's bill last year, with the rape kits, the disparity in how that was looked at across our state. We can do a lot more in the state of Georgia to create sensitivity in law enforcement. I'm fortunate in Cobb County. We have a special victims unit. They're trained district attorneys, assistant district attorneys, law enforcement, counselors, everything. They know what they're doing, but that's not the case everywhere in the state of Georgia. I can't solve all of that in this bill, but as I've spoken with members of your caucus and others, that's a responsibility that we have, and I don't see any end to my crusade to make sure that that continues to happen and that we continue to find ways to be more sensitive to the victims of these crimes.
Representative Oliver.
I know there's been a lot of work on this, and I'm trying to catch up a little bit. Does your bill take away from the victim the decision to submit her allegations to law enforcement?
No, ma'am, it does not.
But it says in line, I'm looking at section B on page, that when an institution receives information which they reasonably believe is a crime, which is a felony, they shall report to law enforcement.
Where are you on B?
Paragraph B, the beginning
Lines
of,
23, 24?
yes.
Okay.
Shall promptly, and then you go to line 26, shall promptly report such crime to campus or other appropriate law enforcement agency. I'm trying to figure out that if an allegations of a crime comes to an institution, maybe even not from the victim, and the institution believes in whatever way and chooses to investigate that a felony is committed, that the crime is submitted to local law enforcement without the victim knowing or having permission to do so. Is that the intent of your bill?
No, that's a fair question. The intent and the actuality of the statute, the way we've crafted it, and as you said, we've spent a lot of time with some very good legal advice walking through how that is modified in the practical reality. We've even gone so far as when it was originally drafted, Representative Oliver, it had the individual reporting duty. Now it is only at basically the institutional level. When you raise it to the level of creating a prosecutorial or punishment for the actual crime of this, then it's a duty for the institutions to report. But it's modified by the several times. Nothing in this subsection shall require a victim of sexual assault to cooperate with law enforcement in any investigation or participate in any subsequent prosecution. I've been assured, and I think we've stated it enough times, that the victim controls this process. We in no way and in no form want to tell the victim that they have to report. The only channel that it gets to is if that victim wants to go the civil authorities route, the prosecution of the crime. At that point, it becomes civil authority, not campus.
I'm focused on the word "or" on line 27, and that's what's causing me to believe that there's perhaps an opportunity for a victim who doesn't wish to be known and doesn't wish to cooperate for the crime to be submitted to law enforcement. You are interpreting, I think you are, this is my second question, institutional investigations for discipline purposes as civil proceedings. It looks to me like beginning on, in paragraph C, beginning on line 38, that, I may be wrong about this, that the institution is not entitled to discipline a student when the institution believes something has happened short of, which may or may not include a felony? That's what I'm confused about.
What we're saying
No
is,
student, beginning on line 44, no student shall be subject to any interim discipline for students arising the same acts that are basis for criminal investigation. So if there's a criminal investigation ongoing, does this say the institution may not discipline, or does it say if there's no criminal investigation, they may not discipline? I'm
it
confused.
says they can continue to act on lines 41 under its current duty of care. What intervened since 2011 was the 2011 Dear Colleague guidance that set up a separate institutional investigatory proceeding and a separate set of due process, which many would say wasn't much due process, but that's a subjective discussion. The institutions, and I've gone over this with the regents and their lawyers, still have the capacity, just as they would with any other felony on campus. If you have an armed robbery or an assault or a murder on campus, there is a duty of care that the institution, under their standardized due process that they already have, can make those interim measures. If you'll look at the interim measures language on line 41, institution may pursue interim measures to meet its necessary duty of care. For many, many years before the 2011 Dear Colleague letters, institutions had the capacity to protect their campuses from murders and assaults and everything else. What this statute does, though, is it takes away those special Title IX sexual assault procedures.
Beginning on line 44, however, no student shall be subject to any interim discipline from acts arising from the same acts or occurrence which are the basis for criminal investigation. What that means to me is that you may not enter into any disciplinary process with a student who is subject to a criminal investigation. I must be wrong about that.
No, I think you are, because it says interim measures such as removing those individuals from that area. Discipline in the sense that you're going to expel, suspend, or in some way take away the rights of an accused
While
without
there's a
due
criminal
process.
investigation. While there's a criminal investigation, you will not allow an institution to suspend a
Representative Olive,
student.
you and I, we can parse our words back and forth.
This is fundamental. This is
It is
fundamental
fundamental,
due
and
process.
It is fundamental due process, and the universities have been participating in it for 100 years with respect to serious felonies on campus. We're not taking that away. And I've talked to the regents' attorneys, and they're of the same opinion.
I'm confused. I remain confused.
I'm sorry.
Dean of the House, Representative Smyrie.
Chairman Earhart, of course, let me first say I appreciate the opportunity to work with you to try to come to some of the areas of concerns that a lot of us have. And in our discussions, most of it is centered around the mandatory reporting and the due process aspect of House Bill 51. Under present law, the victim is not under mandatory reporting as it relates to law enforcement, but to the post-secondary institution. Is that correct?
They can do either.
They can do either. It's a discretionary. Under this bill, once a felony is believed or reasonably believed to that a felony has been committed by a student, then it goes directly to the law enforcement agency. Is that
If the
true?
victim chooses for it to. If the victim chooses not to report it to law enforcement or reports it only to the privileged communication, then at no time does it go to that. Only when the victim has given the university a duty to prosecute that.
What about a
action.
non-party? What if someone else made the accusation that a felony or crime had been committed? What's the methodology there? What's the process?
That's not the victim in that sense. The methodology does not necessarily create a responsibility on the institution at that point. That's one of the areas that you and I have agreed to continue to explore. But my opinion, and the opinion of many others who have worked to craft this so delicately, is that it doesn't, a non-related third party is not going to kick in.
In the process of adjudication, and if a student is reported now to the law enforcement agency, at what point in the process is the victim identified?
The victim, if they choose to have anonymity, is allowed anonymity under this. You have a federal statute, Clary, and the Violence Against Women Act that have significant protections in that arena as well. And they will go side by side with this. This doesn't in any way preempt any of the Clary protections.
Okay. Mr. Chairman, if I could follow up just a couple
Certainly,
more. Are all of our campus law enforcement agents or people that are employed by campus police or campus security, are they post-certified?
All campus police, I've been informed, are post-certified.
I was curious of that to know whether or not.
I didn't know that either until I asked.
Because under the bill, it states that the investigation is conducted by campus law enforcement agency, but the person has to be post-certified. Is that correct?
That's correct, sir.
Okay. And lastly, well, two other things. The interim measures, I talked to you about several that we wanted kind of included in the measure, and that's something I'd like to further discuss with you. The interim measure as it relates to on page 2.
Line 41, yes, sir.
Line 41, where it says the post-secondary institution may pursue interim measures necessary to meet its duty of care. And I'd like to continue to explore that. And the last item, and we've disagreed on this one, but at the same time, Section D, dealing with the federal statute from a statutory standpoint, we would abide by that, but there would be no expression of opinion as it relates to any guidance or any other regulatory
Yes,
opinions.
sir. You and I had a long discussion on that, and that is somewhat of the crux, the differential between regulatory, statutory, and guidance. And we'll continue to discuss that.
All right. Thank you, Mr. Chairman.
Thank you.
Representative Quick.
Thank you, Mr. Chairman. And Chairman Earhart, I've got just a few questions for you, and
Certainly.
then I hope that some of those questions may speak to what Representative Oliver's concern is, and if not, I'm happy to continue to work with her and go through some of this. Is it not true that HB 51 is a general outline of process, which then leaves to the institutions the ability to develop policies and procedures surrounding this framework?
That is correct. We did not want to take, because of the special nature of the institutions and the constitutional nature of the regions, take away their ability to create their own guidelines.
And is it not true that in the bill it applies to felonies committed by students who are enrolled in our institutions or on campus where felonies have been actually perpetrated on campus where we're supposed to be protecting our students?
That's correct.
And with regard to the interim measures question, is it not true that interim measures, as far as our institutions are concerned, are not discipline?
That's correct. They're not discipline. They're measures taken under their duty of care to create a safe campus environment.
And proceeding on to line 44, is it not true that the sentence that Representative Oliver was reading to you in terms of the however, that is modified and descriptively circumscribed by due process at that point? It is at that point that the student shall not be subject to discipline without due process, and that is where the due process kicks in.
That's correct.
And is it not true that although I lobbied heavily and have worked hard on this bill for a pause in final disciplinary actions until criminal charges could proceed, you have overruled me. And in fact, the final disciplinary proceedings All the disciplinary proceedings can proceed. It's just that they must afford due process.
That's correct.
Thank you, Mr. Chairman.
Thank you, Representative Quick.
Representative Henson.
Thank you. I'm over here.
Gotcha.
Some questions about the bill. What happens when both students are not enrolled at the same school? How does this apply? Let's say that the girl's enrolled at Agnes Scott, fellow's a student at Georgia Tech. It occurs at Georgia Tech. How does this now work?
That goes to the question that Representative Quick was propounding on. Specifically, the regents have in-place processes with respect to intercampus code of conduct violations, whether they're small violations or the regents have in-place procedures under which these individuals may be brought to account campus to campus. Currently, it would be the same as it is now in any other serious felony.
Does that include private colleges?
Yes, they have. Well,
Okay.
private colleges are into and of themselves. They have their own set of rules.
But I'm just saying if
They could.
If one is at a private college and one is
That
not.
is correct. If a private
Okay.
college wanted to create their own,
Yeah. Now, I have one or two other questions.
certainly.
Now, our dormitories now have both females and males in the same dorms, correct?
Yes.
What happens if the female accuses a male living in the same dorm of having sexually assaulted her or raped her? Do they move one or the other out while the whole thing is in the process? I mean, because it's sort of saying that, the school's not going to pursue any kind of actions, yet, I mean, we really don't want to leave them in the same dorm, so how does
That's
that
the
work?
interim measures that we're talking about. We spent a good deal of time and effort making sure of this, and the interim measures that a university can take for the victim at the behest of the privilege report are very clear. They can allow that victim to move out of that dormitory. They can allow that victim to withdraw from classes that they may or may not be in with that alleged perpetrator without any penalty. They can take interim measures. What they can't take until and unless there's a finding of guilt is you can't punish somebody in this country until you've proven them guilty for an act. So you can't say, all right, you've made an allegation against this individual, we're going to take them, move them out of their dorm, suspend them from campus, and that kind of thing. At that point, you have to go through due process. But this bill, in a very clear manner, makes sure that the victim themselves can put into place or start into place through interim measures the ability to remove themselves from that environment with no penalty.
I understand removing one or the other, but yet what you're doing is removing any support base that female might have by moving her.
What can I ask you? What support base am I removing specifically?
The support base of her friends. You're moving her into another location where she doesn't have
Only
the
if she wants to be
the
moved.
support base that she has built up, and she does not come. She comes from another state.
She doesn't have to move. Nothing in this bill.
If I was in that situation, I would not want to remain in the same building with
In this
fellows
country,
that I
we are
accuse.
innocent until proven guilty.
I hear
You
you.
have to prove that first before you can punish somebody.
And lastly, who's paying for the lawyers?
Who's paying the bill currently?
No, who would under this?
Actually, Representative, this frees up millions of dollars that we're going to ask the regents to reallocate into sexual assault prevention measures on campus, law enforcement prevention measures, and I have an agreement with them that they will do that.
No,
So-
what I'm asking you, if I was the female, who'd be paying my bill? Likewise, who would be paying
Generally, in
man's bill.
the case of students, it's their parents who pay these bills.
In both cases, so it's their
In both
parents.
cases, that's correct.
You know, this is really going back to a thing of who has the most money.
No, ma'am, it is not.
It does.
It's
I
about
mean,
due process.
if you have someone there whose parents don't have money, you know, where do the lawyers come
Generally,
from? Who defends
let
them?
me direct your attention to, you know who this really is a difficult time for? It's a student who doesn't have money. Did you see the movie To Kill a Mockingbird, Representative Henson?
A long time ago.
Yeah. Who was abused by the system of law in that narrative? It wasn't the son of somebody like myself with resources who, if somebody accuses my son, I can afford an attorney. It's the disadvantaged young man that comes from no money, that has no support, doesn't know where to get the lawyer, who has no ability to take on the powerful attorneys in a university legal office, that's abused by the system. It's not about money.
But likewise, you also have the female having the same situation, not just the male.
Representative Aller.
I perceive that the heart of the due process barriers or obstacles in your mind relate to the disciplinary procedures. And in that, if that's true, it is not accurate to say, correct me if I'm wrong, it's not accurate to say that a perpetrator of a sexual assault has to be convicted by a jury and complete all his appellate opportunities before he may be disciplined. That's not your position, is it?
No, it's not. It's what, let me finish. You asked the question. Now, it is what is prescribed is specific actions against that accused. Universities will still be able to do everything they've always done. This is where Representative Quick and I came back to that. I said, let's make sure they can still do the things they can do. It's the all felonies are created equal provision is what I call it. But currently on campuses, you have these special tribunals, single investigators who function as judge and jury and final arbiter.
You're not
That's
answering,
what you can't do.
You're not focusing on where I'm having trouble.
I'll dance with you, but I'm not going to dance into what you want the answer to be.
You're presuming certain answers and presuming a willingness on my part to dance and talking about something that is very serious, sir.
I'm very serious about this as well.
The disciplinary procedures are a civil procedure. They're not a criminal procedure. They do have significant consequences, and the perpetrator is entitled to due process. But what I can't figure out is whether it's your intent that no disciplinary procedures that result in an expulsion may occur before the perpetrator is convicted of a sexual assault crime.
They can result in the exact same disciplinary measures of any other felony on campus. That's as specific as I can be. I'm just not going to set up a separate set of felonies for one certain felony punishments for one certain felony, which is what we have on campus now. We're making them all the same.
I'm interpreting your answer as you agree with me in terms of no disciplinary expulsion or discipline until the perpetrator is convicted. I believe you
If
just said you
expulsion
agree
is
with
allowed today under the university processes for a felony, it'll be allowed after this bill. I'm not changing that.
That's not what he said.
Chairman Welch.
Thank you, Mr. Chairman. I just wanted to clarify, I think that you made the last point was that this doesn't alter the criminal proceedings that would occur, and in fact, the state would then prosecute those criminal felonies as it would in any other circumstance.
Certainly not.
And then, and that would be at the expenditure of the taxpayers as it is today.
Correct, sir.
And then, is it not further true that the measures in here are simply to guide that when there is going to be disciplinary action against the individual student that has been alleged to have committed, violated the code of conduct, that measure, whatever discipline is going to be imposed, has to come after due process given through their own institution's code of conduct in those proceedings. Is that correct?
That's correct. I guess an example would be if you had a violent murder on campus, a serious felony. The universities today may take significant disciplinary actions for that felony. They'll be able to take that same disciplinary action today. What this bill does is says you can't take a separate disciplinary action inside a special Title IX court with a single investigator. We're going back to where we were pre-2011.
All right, that appears to be all the questions we have. Have a motion do pass. Do we have a second? Have a second? All those in favor, let it be known by saying aye. Aye. All opposed, like sign. No. Just to be safe, Chairman Hatchett, abstain? Okay. Just to be safe, I'm going to ask for division of the House. If you would, please raise your hand and keep it up until we can get counted. I'll let you know when to let it down. All those in favor, please raise your hands. All right, reverse. All opposed. Well, y'all were loud. All right, the yeas have it 35, nays are 10. Bill does move on now to rules. We are adjourned.